All right, good morning, everybody. Welcome, welcome. We're so glad to have you here today. Do you guys know what today is? What we're celebrating at ONU? It is Founders Day, which is really exciting. It's always a good time on Founders Day at ONU. This year is especially significant because we are celebrating our 150th anniversary of the founding of this great university. So in conjunction with Founders Day, we also are hosting the Goldman lecture today. We're so glad that all of you are able to join us for what is going to be a fantastic hour that we've spent together. So I'd like to start by turning the time over to Dean Rose, and then we will introduce this year's presenter.
Thank you, Dan. Usually when the dean talks, it makes people nervous one way or the other. And I'm really excited for the presentation you're going to hear today because the speaker happens to be one of my best friends on the planet. And we have trained JAG officers, FBI officers, FTC lawyers, probably for off and on for the last 10 to 15 years. But I wanted to talk about the Goldman lecture itself and what it means to the College of Law to have that type of commitment. Because, you know, once upon a time, the Goldmans sat in this room, just like you're sitting in this room now. And life went well for them, and they said, we want to give back to the College of Law. We want to make certain that the type of presentations that we heard, the things that made us think, continue. And we're just extremely grateful to Bob and his family for making this possible. And we've had the opportunity to challenge you through the Goldman lecture to make you think about things in different lights, to make you think about law enforcement from all angles, to make you think about what is truly the impact of the law on the jobs that all of us do. And as a former prosecutor and then later on a defense attorney in the Army, I understand the degree to which knowing how the law works and seeing where it connects to you is so important in your development. And we're just extremely grateful to the donor for making this possible. And I wanted to point that out to you because in a very real way, you are them and they are you. You're just in a different arc of the journey of what it means to be part of this particular community. We just extend our heartfelt thanks. And I'm now going to turn it over to Professor Flake, who's going to introduce one of my best friends in the universe, so he is under no pressure to get it right.
Fortunately, what I'm going to read in the bio actually came from Mr. Foreman. So if it's wrong, it's on him. Well, like we mentioned, this year we are honored to have with us Rafe Foreman. Mr. Foreman is a partner at Hutchinson and Foreman in Lubbock, Texas, and he has been representing people who have been wrongfully accused, discriminated against, and or physically and emotionally injured since 1988. He is a trial lawyer, a consultant, and a professor, and he tries cases involving criminal defense, plaintiff's personal injury, civil rights, employment discrimination, wrongful death, excessive force, and also 1983 actions. Mr. Foreman is board certified by the Texas Board of Legal Specialization in the area of criminal law since 1994. He and his law partner, Susan Hutchinson, have obtained many record-setting jury verdicts throughout Texas and the country. Their most recent verdict was obtained in the Dallas Federal Court in May of 2021, where they received a record verdict for their client, a 72-year-old man who was discriminated against based on his gender. They have multiple cases also pending before the United States Supreme Court. Mr. Foreman has been voted a super lawyer for many years in Texas. He is both a retired and a current law professor. He's been on the Trial Lawyers College faculty for 21 years and remains an adjunct professor of law at Stetson Law. Mr. Foreman retired from UMKC Law and the Douglas Strip Endowed Chair in Advocacy after leading the team to the highest advocacy ranking in the school's history. Mr. Foreman, along with Professor Tobin, created the only jury selection trial competition in the country, and it was known as the Show Me Challenge. Mr. Foreman holds an undergraduate degree from Texas A&M University and a law degree from Texas Tech School of Law. He is passionate about rectifying discrimination, and still has a few jury trials left in him, so he says. So please join me in welcoming Mr. Rafe Foreman.
Is this working?
Yeah.
Well, it's so nice to be here. I tell you, I'm humbled to be invited. And I've been practicing, I was sitting where you were 35, 36 years ago. I've been practicing almost 34 years. And it doesn't seem like that long ago when I was sitting where you are. So I'm kind of an interactive speaker. I need your help. So if you'll help me, I'm going to be calling on you a little bit. You say, well, you don't know my name. That's okay. We'll figure it out. I just want to say some thank yous because you all have been so gracious to me. I'd like to say thank you to one of my best friends, Charlie Rose, for the invitation. I'd like to thank the Goldman series for the opportunity. And I'd like to thank you for coming and listening. I would like to thank the Pettit College of Law because I was treated so warmly yesterday. I got to see in this jury room that's next to this courtroom legal document that comes from the 12th or 13th century. It's amazing. I saw a pocket book of the Magna Carta, which is just amazing to me. And then I saw, and I didn't realize that, is it Campisi?
Celebrezzi.
Celebrezzi. I didn't realize that Judge Celebrezzi was on the Court of Appeals. And I've been to 2 presidential libraries, not that many, but the 2 I've been to, the documents that I saw in this room revel anything that I've seen in a presidential library. It really is an honor for me to be here, and it's really a special occasion. Now, I've got to cram 32 to 34 years of legal practice into 45 minutes. So I'm gonna get started. But I'm a farm boy from down in Idlewood, Texas. And so I got to tell you my combine story. The Department of Motor Vehicles passed a new law that in order to drive a truck hauling a combine with the header and the combine disassembled on the back, that you had to have a special license. So this corn and soybean farmer goes down to the DMV to take his test, and they enacted a new rule. You get interviewed by the DMV. So the highway patrol that may give you a ticket gets to interview you and give his or her opinion about whether or not you're qualified to make this trip and get this license. So farmer says, I'm ready. The hypothetical scenario was as follows. You're in an 18-wheeler going down a 6% slope. At the bottom of the slope is a river, and there's a 1-lane bridge down at the bottom. You're hauling a combine with the header and the machine on the back. You're overweight, and your brakes go out. What's the first thing you do? The farmer didn't even hesitate. He said, I wake up Clyde. He said, who's Clyde? He says, my dog. Why do you wake up Clyde? Because he's never seen a wreck like the one we're getting ready to have. How many of you are law students? Raise your hand. Okay, I realize that most of you are here probably against your will. There's some force being applied to you by the professor that you need to come and attend this lecture. So I get that. I also realize that the last thing you want to do is have a boring constitutional discussion about the law. Good news is, I'd fall asleep during that discussion too, so that's not the way we're going to go. But I do want to kind of focus you just a little bit. So I've got an attention getter, nothing like the truth, so let's start. I want to talk to you about an advocacy skill called role reversal. Are you able to reverse roles? Have you ever done it before? Will you try it with me? What I want you to do is to not be present in this room. I want you to transpose yourself to travel somewhere else, and I'm going to take you there, but I want you to go with me and forget that you're looking at this shaky old man up here in this room at the law school, and go with me just for a minute. Will you promise? All right, so, and you can close your eyes if you need that assistance. If I'm too distracting for you, you just close your eye. You're in a 6x8 cement room. You have no windows, and there's only one door. Inside this room, there is fecal material and feces completely on the floor, on the walls, on the ceiling, and packed inside the water faucet. It's completely clogged with human feces, and so is the toilet, which doesn't work. You are left in this cement box for 6 days, which you do not have water and you do not have food. Now, you have an opportunity to eat the food, but in these conditions, you choose not to eat the food. After 6 days, they remove you to another 6x8 block, cement walls, no windows, one door. Only this one has no toilet and no water fountain. It is completely deep in liquid human waste. And you're told that there's no facility for you to use, that over in the corner is a drain, but it's completely clogged. And by the way, you're naked. You have no blanket, you have no clothes, and you have no place to sit. It's just a cement floor. You have to lay in human filth if you want to sit down or lay down. Can you picture that? Where are we? Somebody tell me where we are.
I think this is a case from Texas, right?
Well to go, man. Spoiler alert. I was hoping somebody would say we're in a prison camp. We're in a dungeon somewhere in some medieval castle. But unfortunately, we're in Lubbock, Texas, where I just flew from yesterday. What year are we? What year is it?
Like the last 5 years, right?
How about last year? 2021. We're not talking about 500 years ago. We're not talking about 100 years ago. We're not even talking about 36 months ago. We're talking about 2021, Lubbock, Texas. Trent Taylor is the client. That's him. He was serving an 11-year robbery conviction. They moved him to the Montford unit in Lubbock, Texas, which is the psychiatric unit, and it's the only unit in the area that has an intensive care unit in the hospital. So if you're sick or mentally ill, you're going to go to Montford. And so that's where Mr. Taylor found himself. I want to quote, not from the pleadings, but from the United States Supreme Court, so you can get the gravity of this situation. This state inmate brought a 1983 action alleging that prison officials housed him in an unconstitutional condition and were deliberately indifferent to his health and safety. You need to remember those terms, deliberate indifference, because we're going to look at the Civil Rights Act, its history, its escape hatch, and deliberate indifference is going to be a key concept that I need you to pay attention to, because deliberate indifference is the standard to which we're going to hold officers. Again, I'm quoting from the Supreme Court opinion. Taylor alleges that for 6 full days in September of 2013, correctional officers confined him in a pair of shockingly unsanitary cells. The first cell was covered nearly floor to ceiling with massive amounts of feces all over the floor, ceiling, window, and walls, even packed in a water faucet. Also, he didn't have anything to eat or drink for the nearly 4 days. Correctional officers then moved him to a second frigidly cold cell that was equipped with only a clogged drain in the floor for bodily waste. The drain overflowed and raw sewage spilled on the floor, and lacking a bunk or any place to sit, Taylor was confined without clothing, and he slept naked in the sewage. The trial court in Lubbock dismissed the case based on qualified immunity. And we're going to talk a lot. That's what I'm here to talk to you about, is qualified immunity and what is it, and where did it come from. But qualified immunity was the basis of the dismissal. Then it goes up to the Fifth Circuit Court of Appeals in New Orleans. What do? They affirm. So then it goes to the United States Supreme Court, where you notice that I said 2013, the opinion was either 2020 or 2021. It was very recent. And the Supreme Court of the United States said that the Fifth Circuit erred in granting the qualified immunity to the officers. And they made this quote that I want you to understand, because this is the law of the land. Qualified immunity shields an officer from suit when she makes a decision that, even if constitutionally deficient, reasonably misapprehends the law governing the circumstances she confronted. Okay? No reasonable correctional officer could have concluded that under the circumstances of this case, it was constitutionally permissible to house Taylor in such a deplorable, unsanitary condition. They created a new test. They created a new exception. When I was sitting in your position 35 years ago, there was no such thing as the obviousness exception to qualified immunity. In my practice, which I was licensed in 1988, so do the math. Never have I, in my career, since I've been a law student, seen a case where the United States Supreme Court makes an exception, a divergence to qualified immunity. Until now. And that's the guy. That's the client. It wasn't in a prison cell. It wasn't in years gone by. It was currently just in your lifetime. Anybody know who that is? Some of you older folks might want to play.
Rodney King.
Rodney King. Does anybody know who Rodney King is?
He was the guy who got beaten by the 6 LAPD officers.
I don't know if it was 6, but he was beaten on national TV during the LA fires or LA riots. And my colleague at the Trial Lawyers College, Milton Grimes, was his attorney. Rodney King was the first person in my lifetime. I'm not going to say the first person in the history of the world, because I don't know about the history of the world, and I wasn't here all that time. But during my lifetime, Rodney King was the first person that I saw with my own eyes be what I considered as a citizen to be treated unfairly by law enforcement. We got to see it on national TV. It was in 92, I believe. In 92, we saw him laying on the ground face down and officers continually kicking and beating him. So was that the thing that prompted the Civil Rights Act? Anybody know when the Civil Rights Act was passed? Let's look at that. Yes.
64.
You got all the answers. Now, I apologize for this picture. The reason that it's up there is because the Civil Rights Act was originally passed as the Ku Klux Klan Act. It was passed to prevent former slaves from suffering indignities at the hands of law enforcement. And it sat idly by for years and years and years until the 60s and the 70s revitalized it. So sometimes you hear of the 42 USC 1983 is the civil rights section. And that's the civil rights statute. We don't refer to it as much as the Ku Klux Klan Act anymore, but that's what it was started as. Let's take a look at what it says. Every person under color of any statute, ordinance, and remember under color. I'm going to come to that in my lecture in a moment. Of the state or territory of the District of Columbia, which subjects or causes to be subjected any citizen or other person within this jurisdiction. A deprivation of any, highlight, bold, and underline, any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit, and equity. I'm not going to read the rest of it, but I want you to study that and show me where in the literal language the concept of qualified immunity is alluded to, mentioned, or even subliminally suggested. It's not there. Qualified immunity has no basis in the Constitution. It has no basis in the statutory law, and it is purely a creation of courts. It is purely court created. And you say, wait a minute, in law school, they're teaching us, and I know they're teaching you that here because this is a experiential learning opportunity in law school. Judges aren't supposed to legislate from the bench, but that's exactly what we have going on with the concept of qualified immunity. So what is qualified immunity? Does anybody know?
Prevents law enforcement being sued in civil suits if at the time when they committed an arrest or whatever, they were unaware of what they were doing with those.
Well, that's one of the concepts, is whether they were unaware of what they were doing. That seems like a pretty easy answer, isn't it? I didn't know I was doing wrong. Wouldn't everybody say that? Wouldn't that be the defense every time if it was that simple? So qualified immunity is a shield. The 1983 Civil Rights Act gives us all these civil rights protections, and I want to talk to you about some of the categories that I've litigated. In 1983, under 42 USC 1983, an officer may be liable for false arrest, false imprisonment, malicious prosecution, malicious abuse of process, conspiracy to violate due process rights, excessive force, and you can even, under some circumstances, have a bystander liability claim. So all of that is protected. So what's qualified immunity got to do with it? Qualified immunity says that it's a shield, it's a protection, it's a bar to any recovery under certain circumstances, and let's look at those now. Qualified immunity has really three components now as it's morphed from its early beginnings to its current application. Did the officer violate a constitutional right? That's step one. The problem is all the courts in the circuit have said, nah, you don't really, in the Supreme Court, you don't really need to bother with step number one. So courts don't bother with it. Courts don't even write about it. Step number one is not even relevant. So you just go to step number two. Did the officer know that their actions were clearly established right? Oh my gosh, we could spend an entire semester in a 3-hour course talking about this issue. Because in 1871, there were no defenses. Have you ever heard that no one's above the law? Raise your hand. It's not true. It's not true at all. There are citizens in this country that are above the law. Not because I think they are, not because I tell you they are, because they are. They are above the law. And qualified immunity is that thing that transports them above the law. So how does it work? Clearly established law. All right. If in 1871 there were no legal defenses available because you work for the government, how did we then create the legal defenses upon which qualified immunity is based? I'll tell you how we did it. You're not going to like it. They made them up. They created them out of nothing. They literally made it up. And they're still making it up in 2021 and 2022. You don't have to take my word for it. Look into it. Deliberate indifference. You have to be not accidentally in violation of a constitutional right. In fact, the courts have said that the qualified immunity only protects those who are clearly ignorant or incompetent. It doesn't protect those, and it doesn't protect those who act deliberately. So you have to prove that the officer knew what he or she was doing was a violation of a protected fundamental right, and they didn't care. Can you imagine why anybody takes one of these cases? Because the vast majority of the cases that are presented in court, in federal court under 1983, are dismissed under 12b-6. If you make it past 12b-6, they're dismissed on summary judgment. And so when you sign up for a civil rights case, you're signing up for a 7-year commitment. That's just some of my averages. Because you have to win twice. You have to win at the district court on the 12b-6 or the summary judgment, and then get it. And if you lose, you got to appeal it to the 6th Circuit here. We are in the 5th Circuit in Texas. And then if a miracle happens, you get sent back down to the trial court 4 or 5 years later. And then you get to have maybe a trial. And then you start all over again. You appeal the trial and you go to the Supreme Court. Why would anybody take a case like that? Well, I'm a board certified criminal specialist. I've been representing people wrongfully accused of crime for 33 years. And in my representation of criminals, I started noticing that a lot of them were given what they call a rough ride. You know what a rough ride is? It's where you don't go in bruised up, but you come out bruised up, maybe dead. And so I had a keen interest for protecting those people because, you know, if the Constitution doesn't apply to the least of us, it doesn't apply to any of us. But some of you are thinking, well, I'm never going to commit a crime. I ain't got to worry about this. You know, I'm not above the law. I'm just not stupid enough to violate it. Well, let's see if you feel that way. How many of you have ever had a car wreck? I'm not trying to get you to confess anything that would be admissible in court, but maybe it was somebody else hit you. But a few of you have had a car wreck. How many of you think that you could suffer head trauma in a car wreck? Okay, well, maybe this law does apply to you. Let's wait and see. How many of you have heard of diabetes? Okay, how many of you think that untreated, or if you go off your medication, causes a problem for, I don't know, about 26 million Americans that have diabetes currently? You can think of that? Okay. So this might apply to you. I want you to understand it applies to you because if the story is not about the listener, they will not listen. And so I want to tell you about Raul Garcia, another one of my cases. And it'd take 2 semesters for me to tell you about my cases, but I got to tell you about Raul Garcia because this is in Lubbock, Texas, and it's happening right now as we speak. Raul Garcia has a port where he receives chemotherapy for his cancer. It's visible to anybody, a 3-year-old, if you look at his chest. He also wears medical ID bracelets like the one I have here. His were rubber. Mine's a little more permanent, but he had on double ID bracelets. He goes to the United Supermarket on 50th Street in Lubbock, Texas, because his wife is also a cancer patient and she's actively receiving chemotherapy at the hospital. And he wants to get her some decent non-hospital food. So he goes to the they have a hot buffet in the grocery store. He goes to the hot buffet line to get her some food and starts suffering from a diabetic episode. Now, the first thing that happens is he has slurred speech. He has problems, he's confused. He has problems communicating. So the manager calls the Lubbock Police Department. Lubbock Police Department show up. They spend less than 2 minutes with Raul Garcia. They cuff him behind his back because that's the proper way to cuff a person. I'm not complaining about that. They set him in the back seat on his hands, and within 30 seconds, he's unconscious. He's slumped over and non-responsive. They're banging on the cage. Wake up, set up, but he's not. Instead of driving by the hospital, I don't know, because a guy without oxygen might not have but about 3 or 5 minutes to live without brain damage, they take him to the Lubbock detention facility. All this is on video. They walk him in there. You can clearly see his medical ID bracelets, and you can see when the officer handcuffed him, he cuffed him over his medical ID bracelets. So he knows they're there. Instead of processing Mr. Garcia and booking him as is the policy and requirement, they put him in a cell where they find him unresponsive, having suffered a stroke. District judge dismisses the suit. Failure to state a claim and qualified immunity. How is it called? And it's on appeal in the 5th Circuit right now. How is it qualified immunity to consciously disregard the knowing, obvious health of an inmate? Well, the Tyler opinion from the Supreme Court had not been written yet. But we're talking about a man that had to sleep in fecal material and human waste. The officers are not entitled to qualified immunity. A guy has a stroke, they are entitled for qualified immunity. And then now I want to talk to you about all the cases where my clients are pushing up daisies. They're dead and they receive qualified immunity. My point is, qualified immunity is not applied equally across the circuits. It's not applied equally even in the same state, because it is a judicially created doctrine that moves the goalpost in every case. And so your challenge is going to be, what do we do about that? The obviousness requirement of the Taylor case that we looked at should apply to a man who has 2 medical bracelets. This is my opinion. I'm not quoting from the case. We're hoping that they'll make this ruling. 2 ID bracelets, got a chemotherapy port, and has diabetes. This one says diabetes, this one says cancer patient with a port. Okay, they knew he had a medical condition. They even talk about it on the way. How are they not deliberately indifferent? Well, that supports, and by the way, there is many law enforcement agencies and officers that support the abolition of qualified immunity, because what does it do? It erodes the public trust. It makes the public have no faith in our men and women who are serving our community and trying to keep us safe. The abolition of qualified immunity is called for, not just limited exceptions, but we got to play with the hand we're dealt. The obviousness requirement is yet to be tested to see whether it applies to anything other than fecal material. And I don't mean this lightheartedly, because you need to understand that the absurd way the Supreme Court is requiring us to determine whether it's a clearly established law is whether or not there is a case exactly on point with the exact facts of this case. Well, now, wait a minute. Do you think things have changed since 1871? Back then, we might have been chased by a policeman on a horse, but that probably doesn't happen unless you're in New Orleans or a town that has a mounted police force. So if it's not happened before exactly like it's happened in this case, it's not clearly established, you lose. That is real. And it's got to change. The good faith exception is another excuse or exception that allows qualified immunity. The exception states, well, if you in good faith thought you were following the law, and it comes from a constable who's serving some trespass papers, and he thought it was legitimate to evict this person, and it turns out that the law was later ruled unconstitutional. He doesn't have to predict the future. He's not liable. He's entitled to qualified immunity under that scenario. But how did this country get formed? Wasn't there something, I understand a Tea Party, but I don't think it was all about the Tea Party. This country got formed because of taxation without representation. This country got formed because some expatriates from Britain decided that we needed a government that was more responsive to the people, not to the monarch. And I've written a paper that's got 100 pages in it, and I know you won't read it. It's got an appendix, and I want you to, if you're on law review, forgive me, I didn't check every single one of my science for Blue Book form. But what I've done in the appendix is I've literally copied and pasted from actual lawsuits that we're involved in. They're my lawsuits, they're my cases. And you can see the pleadings, so you get the full context of this situation that I can't possibly give you in 45 minutes. So that's in the appendix. In the body of the paper, it talks about immunity. And by the way, the reason I bring up Great Britain is because in the paper, you'll see that it's easier to sue the monarch in Great Britain than it is a police officer or a district attorney in the United States. We have more immunity than the Queen. Well, maybe not the Queen, but her consort and her officers. The reason I put the Queen's Royal Constabulary of Investigation is because thanks to Charlie Rose, Dean Rose, he introduced me to the former Lord Advocate of Scotland, Dame Ailish Angelini, who was hired by the Queen to conduct an investigation of all in custody deaths up to 2017. And I was a consulting expert on that report because of my experience with taser cases in 1983. Well, you'll be surprised. I think that the period of time that we covered was about 10 years, and there were 17 in custody deaths in the UK. There was that many the week that I was in Scotland in the United States. Do you understand that we have an epidemic of killings in our legal justice system, in custody deaths? In 2019, the Washington Post published the data from 2019 1,006 people were shot by police officers and tens of thousands were wounded. And the reason I put that up there is to remind myself to tell you about what I witnessed on the streets of Edinburgh. I was with a colleague. We were teaching at the trial advocacy program at Charlie's former university down in Oxford, England. But we were in Edinburgh. And there was a man that was so drunk and intoxicated that he couldn't hold himself up. He had to hold on to the light pole in order to remain standing. A police car comes, 3 police officers jump out, and I'm literally this close to this. These officers triage this gentleman. They put themselves in a triangle around him, and he's combative. He kind of swings at the female officer, doesn't hit her, she ducks, and he swings. And I told my colleague, I said, right now, that guy would die in America. Because the first thing that would happen is they would taser him, and he was an overweight like me. He probably outweighed me 100 pounds. They would taser him, put him in the prone position, which means lay him on his stomach, put weight on his back, and he'd be dead from positional asphyxiation. How do I know that? Because I've seen it happen so many times before in my cases. But instead, these officers triage this man. They eventually get him by the hand and put him in the police car. And I talked to the head captain, who I was astounded, didn't tell me to get out of here, get back, quit filming. He acted like I didn't even exist. And I said, what jail are y'all gonna take him to? And he said, jail? We're not taking him to jail. He's not a criminal. He's just drunk. We're taking him to the hospital. You could have bowled me over with a feather. I just couldn't believe it. Why do I tell you that? Because there is another way. There is another way than to beat people, to abuse people, to make people lay in feces-covered cells without food and water. There's a better way. We're supposed to be the country that stands up for human rights, that fights against human indecency. That's who we're supposed to be. We need to do a better job. Brianna Taylor, I know y'all all know about Brianna Taylor's case. Unfortunately, she was killed by her own officers. I don't know if you anybody recognize who that is? That's Michael Ferguson. He's the one, Michael Brown from Ferguson, Missouri. He's the one that had his hands up on his knees when he was shot and prompted the moniker, hands up, don't shoot. Anybody know who that is? Who is that? Who's the officer kneeling on his back? Chevron. Now you say, wait a minute, qualified immunity, does that apply to criminal cases? Does it? Anybody want to tell me? Don't worry, there's no grade pending. Does qualified immunity apply to criminal cases? What do you think? What do you say?
Yes.
No.
Okay.
It's not supposed to. But in my 34-year career, going back to Rodney King in 1992, those officers were no bill by the grand jury. Many officers are never brought on charges. It's only during your lifetime, during your law school career and your college career, that the tide has started to turn and police officers are being charged with crime. I'm not sure how you say his name, it's French. Chauvin, maybe, Officer Chauvin, was tried and convicted in state court as well as many of the officers who stood around and watched and didn't offer assistance. But let me tell you, you know who Tony Tempa is? Anybody? Anybody ever heard of Tempa? Come on, no one? Even you haven't heard of Tony? Well, let me tell you about Tony Tempa. As soon as I can find my notes here, I want to get it right. Mr. Temple was a 32-year-old. By the way, this is one of the cases we're litigating. Mr. Temple was a 32-year-old business owner from Rockwall, Texas. Sound familiar? Any of y'all got parents that are business owners? Any of y'all business owners? We're not talking about a hard criminal here. We're talking about a business owner from Rockwall, Texas. He's down on Mockingbird Street in Dallas, which is the street that goes to Southwest Airlines Love Field, if you're familiar with that area. And Mr. Tempa suffered from schizophrenia, anxiety, and depression. He calls the police himself, Mr. Tempa, and says, I'm having some mental problems. I'm anxious, I'm scared, I'm fearful. I haven't taken my medicine in a while. Could you please send someone? And he didn't know to ask for a CIT trained officer, crisis intervention training, but he's asking to be taken to the hospital. He's calling himself to be taken to the hospital. A security guard comes out, the Dallas Police Department comes out, and for reasons unexpected, but not unexplained, I mean, he is suffering from a mental crisis here. Tony decides to just run across the street. Well, police officers don't like it when they're trying to talk to you and you run off. So they told him quit running. He doesn't. So they go catch him. They handcuff him behind his back, which is the proper technique. They put him face down on the ground. But while his face is in the ground, he can't breathe the dirt because he's not over on his side. He's literally face down in sand and dirt. The officer's kneeling in his back. Now, let me tell you what happened there. For 14 minutes, the officer kneeled in Mr. Tempa's back. Now, wait a minute. Mr. Tempa hasn't committed a crime. Mr. Tempa wasn't called in by somebody reporting that he was committing a crime. Mr. Tempa called and asked for medical help himself. At 11 minutes, he stopped moving. He stopped gagging. He stopped coughing. He stopped responding. You would think at that time the officer would get up off him, but he didn't. He stayed on him for another 3 minutes and some change. When the paramedics show up, they're astounded because here's a guy that's non-responsive. They load him in the ambulance, and while they're putting him on the gurney to load him, one of the officers says, I hope I didn't kill him. Laugh, laugh, for about 2 minutes on the tape. Before the paramedics shut the door, he came to report that Mr. Tempa was dead. He died from positional asphyxiation and weight being distributed on his neck just in the same exact manner as George Floyd. Well, why haven't you heard about this case? Well, I'll tell you why. Because the district court threw it out for qualified immunity. These officers didn't violate a constitutionally protected fundamental right. I thought right to life, living, breathing might be a protected constitutional right. Goes up to the Fifth Circuit, which always, almost, rules for the officers and sustains qualified immunity in the dismissal. But in a rare Fifth Circuit opinion, the Fifth Circuit reversed on one issue and affirmed on one issue. They affirmed against the paramedics because after all, the paramedics, by the time they showed up, Mr. Temple was dead. So the court granted qualified immunity to the paramedics, but reversed the grant of qualified immunity to the officers. So we're going to get to go to trial in Dallas court. You say, well, why haven't we heard about that case? It's made the national news. It's made the national news. If the Dallas Morning News is national news, I'm sure you read the Dallas Morning News every day. You know, it's on the AP Wire. You can text it right now and learn all about it. Probably find out some stuff that I've misstated, but you know, I'm old. The bottom line is Mr. Tempa is going to get his day in court. But how long did he have to wait? You see, the justice delayed is justice denied. Who do you think is prosecuting Mr. Tempa's case? He's dead. He's not prosecuting it. Who's prosecuting this case? Who are the plaintiffs? His parents, his mother, and his father. And are we going to deny and delay justice to the point where they have to die before the case is ever resolved? Because it's been years. It's already gone to the district court, to the Fifth Circuit. Now it's going to go back to the district court, and it's going to go back up the appellate line again. And I see that I'm running out of time quick. Anybody recognize these three goons? Who are they? The one on the left is Greg. Travis is in the middle, McMichael. And William Bryan is the one on the right. These two, father and son, got LWOP, life without parole. And the one on the right got life, and he'll be eligible for parole in 30 years. Why did qualified immunity not protect these guys?
As to my understanding, they are not police officers.
They are not police officers. So remember when I read the statute, acting under color of law? These guys are just vigilantes. They're not acting under color of law. Or wait a minute. Is a citizen's arrest a legal thing that operates under color of law? Stay tuned. Not with these people, but that argument is going to be made again and again. Didn't work for these gentlemen. Use of force continuum prevents escalation by officers. And I want to talk to you about the obviousness exception. Because it is one of the greatest civil rights victories in my career, not in the history of the world, not in the history of the country, but in the last 35 years, this is a victory. What is obvious? I want to leave you with this. We have got to bring truth back into the courtroom. We've got to bring truth back to our discussions with our spouses, our friends, our colleagues. I have taught for a lot of years that the facts don't matter. Say it with me, the facts don't matter. Well, if the facts don't matter, what does matter in a case? The jury or the judge's perception of the facts. We've got to change that, folks. The facts should matter. Whether the facts do matter is going to be dependent on you. Because you say, well, what difference can I make? I'm only one person. I have a quote about that I'd like to share with you. I'd also like to remind you of Cicero's quote about control thyself. Control thyself encompasses stop lying, stop cheating, stop tolerating those that do, in my opinion. I want to leave you with this closing quote. Best laid plans. You say, what difference can one person make? The obviousness exception was handled by one lawyer who had a passion, who literally heard it from a chat group and contacted the Taylors and took that case to the Supreme Court and changed the law for all of us. That's what difference one person can make. Never doubt that a small group of thoughtful, committed citizens can change the world. Indeed, it's the only thing that ever has. Margaret Mead. Thank you. Do we have time for questions, or I think we got a hard stop?
Yeah, if you want to maybe meet people outside.
I'd be happy to talk to anybody.
Do that.
That would be great.
Thank you, everybody, for coming. We sure appreciate your participation. And also, obviously, special thanks to our Professor Foreman for coming. So we appreciate it, and thank you to everyone.
All right.